9 justices reviewed the case, and their decision is already beginning to shape how retirement benefits are handled for millions of Americans across the country. This was a significant ruling from the Supreme Court that changes the way courts look at decisions made by federal agencies, including the Social Security Administration. This isn't about cutting benefits or changing who qualifies. It's about how legal disputes over benefits are resolved when someone disagrees with an agency decision. For people who have worked for decades and paid into the system, this ruling strengthens the possibility of getting an independent review if something feels off with their retirement payments, disability claim, or survivor benefits. Let's walk through what happened and what it really means for everyday retirees and those planning for retirement. Social Security provides monthly payments that help cover essential expenses like rent or mortgage, groceries, prescription medications, utilities, and other basic needs. For many older Americans, these checks make the difference between stability and financial stress every single month. The Supreme Court's decision in Loper Bright Enterprises v. Raimondo overturned a long-standing legal principle called Chevron deference. That principle had been in place for about 40 years and influenced how federal agencies operated across many programs. Under the old Chevron framework, when a federal law was unclear or had some ambiguity, courts were often required to defer to the federal agency's interpretation as long as that interpretation was reasonable. This gave agencies like the Social Security Administration a lot of power to decide what the rules meant in practice. Courts didn't always have to agree with the agency, but they had to give them the benefit of the doubt on ambiguous parts of the law. This system developed in the 1980s and was applied in thousands of cases over the decades that followed. The Supreme Court decided that this approach no longer fits with the Administrative Procedure Act, which requires courts to exercise their own independent judgment on questions of law. Judges can still listen to and consider the agency's views, experience, and reasoning, but they are no longer automatically required to side with the agency just because the statute isn't crystal clear. This restores a more traditional understanding of the separation of powers, where courts interpret the law and agencies carry it out. This shift didn't come out of nowhere. Over the years, many people felt frustrated when their benefit amounts were lower than expected, claims were denied, or payments were reduced without what felt like a clear explanation. The appeals process inside the agency could sometimes feel like the agency was reviewing its own work with limited outside checks. Now, when those decisions are challenged in federal court on legal grounds, judges will take a fresh, independent look at what the actual law says. It's important to be clear about what this ruling does and does not do. It does not reduce anyone's current benefits. It does not change eligibility rules, cut funding, or alter the basic structure of Social Security. What it changes is the balance in legal disputes. Retirees and claimants now have a stronger opportunity for courts to independently interpret the statutes when there's disagreement about the meaning of the law. Many Social Security cases still turn on factual questions, things like medical evidence for disability claims, work history, or earnings records. Those factual findings continue to be reviewed under the long-standing substantial evidence standard, which remains unchanged. The bigger impact of this ruling is on pure questions of legal interpretation. For example, how a particular section of the Social Security Act should be read when the language is open to more than one reasonable understanding. Let's talk in more detail about some of the areas where this could matter most for retirees. First, Social Security Disability Insurance, or SSDI. Initial denial rates for SSDI applications have been high for a long time, often above 60–70% at the first level. Many denials involve how the agency interprets medical criteria, functional limitations, residual functional capacity, or how the law defines the ability to perform past work or any other work in the national economy. Under the previous system, courts often deferred to the agency's reading of those rules. Now, if someone believes the agency misapplied the legal standard to their condition, they may have a better chance at getting an independent judicial review that focuses directly on the statutory language. This is especially relevant for people with chronic conditions, mental health issues, or multiple impairments that are harder to document but still meet the legal definition of disability. Second, survivor benefits. When a spouse or former spouse passes away, the surviving partner may be entitled to benefits based on the deceased worker's earnings record. There are detailed rules about marriage duration, generally at least 9 months in many cases, timing of applications, remarriage, and how benefits coordinate with other programs like pensions or disability benefits. Agencies had broad latitude to interpret gray areas in these rules. Those interpretations can now face closer independent scrutiny in court, which may help survivors who felt their claims were unfairly narrowed. This can be particularly meaningful for widows and widowers who are suddenly managing finances alone after decades of shared planning. Third, retirement benefit calculations and timing rules. This includes decisions about claiming benefits early, reduced amounts, delaying past full retirement age, delayed retirement credits, how pensions from non-covered government employment affect benefits through the windfall elimination provision, WEP, or government pension offset, GPO, and how earnings records are calculated when someone has worked in a mix of covered and non-covered jobs. Some of these complex rules have led to administrative interpretations that reduced monthly payments for certain retirees by noticeable amounts over the years. Challenges to those interpretations now rest on different legal footing, with courts required to exercise independent judgment. For example, someone who worked as a teacher or firefighter for part of their career might seek clearer evaluation of how those non-covered earnings impact their overall benefit. The same applies to divorced individuals who may qualify for benefits based on an ex-spouse's record. The ruling also has implications for how the agency operates going forward. Decision-makers inside the Social Security Administration know their legal interpretations can face genuine independent review. This awareness can encourage more careful, well-reasoned decisions from the start. It creates a form of accountability that may improve the overall fairness, transparency, and consistency of the system over time. Agencies may also issue clearer guidance and explanations in their notices to reduce ambiguity that could lead to future disputes. Over the long term, this could result in fewer initial denials that are based primarily on interpretive differences rather than clear statutory requirements. It may also lead to better training for staff and more consistent application of rules nationwide. Now, let's look at the practical side for people in different parts of the country. States with large retiree populations and higher numbers of appeals tend to see more activity. Places like Florida, California, Texas, Pennsylvania, Ohio, Michigan, Georgia, Illinois, New York, and North Carolina often have significant volumes of Social Security cases. Some states have had longer backlogs in disability claims and hearings due to population size and demand. While the agency has been working to reduce those backlogs through technology upgrades, more staff, and process improvements, the new legal standard could affect how pending appeals that involve legal interpretation are handled in federal courts located in those states. Retirees in states with higher costs of living may feel the impact more directly because every dollar in their monthly benefit matters even more for covering housing and health care. If you live in one of these states or have a case currently moving through the system, the change means that federal judges will apply their own reading of the law rather than defaulting to the agency's position on ambiguous points. This doesn't guarantee a win for every claimant, but it opens the door wider for a balanced and independent review. For people who already had a final denial in the past, the situation is more limited. Federal law has strict deadlines for appealing agency decisions, often 60 days for many steps. A new Supreme Court ruling generally doesn't automatically reopen old cases that are well beyond those deadlines. However, if you have a case that is still active, recently decided, or in the appeals pipeline, it's worth speaking with an attorney who specializes in Social Security law. Some legal mechanisms, such as motions based on a change in the legal landscape, may be explored in appropriate situations, but success is never guaranteed and depends heavily on the specific facts, timing, and procedural status of your case. Consulting a professional early can help you understand whether your situation qualifies for any additional review. For those approaching retirement, say people in their 50s or early 60s, this ruling creates a different environment for future decisions. When you eventually apply for benefits, any interpretive disputes that arise will be reviewed with courts exercising independent judgment. That knowledge may lead the agency to be more transparent and thorough in explaining its decisions from the beginning. It also gives future retirees more confidence that the rules will be applied based on a clear reading of the law rather than internal agency preferences. This is a good time to review your earnings history, estimate your benefits at different claiming ages, and consider how spousal or survivor options might fit into your overall plan. Self-employed individuals and those with irregular work histories should pay special attention to their earnings records, since small discrepancies can affect final benefit amounts. It's also helpful to understand the broader context. The Social Security Act is a detailed and complex law passed in 1935 and amended many times since. Over decades, the agency has issued thousands of pages of regulations, Social Security rulings, and guidance documents to implement it. Many of those were upheld under Chevron deference. Going forward, challenges to new interpretations or regulations will be decided on the strength of the statutory language, the agency's reasoning, and traditional tools of statutory interpretation. Past decisions that became final under the old system generally remain settled due to principles of finality and administrative efficiency. Another important point, this ruling applies across many federal agencies, not just Social Security, but for retirees, the direct connection is to how benefits are calculated, awarded, adjusted, and reviewed. It reinforces the idea that courts are the final interpreters of the law, which is consistent with traditional separation of powers principles in the Constitution. If you are helping a parent or spouse with benefits, or if you're managing your own retirement planning, here are some expanded practical steps worth considering. Create and regularly check your My Social Security online account to review your earnings record, estimated benefits, and any notices. Keep organized records of every letter, decision, and communication with the Social Security Administration in a dedicated folder or digital file. If you receive a decision you disagree with, act quickly. Appeal deadlines are firm, and missing them usually means losing your right to challenge. Consider consulting a knowledgeable attorney or accredited representative early, especially if the issue involves complex legal interpretation, WEP, GPO, or survivor benefits. Many work on contingency or offer initial consultations. Explore free or low-cost resources through legal aid societies, state bar associations, or senior advocacy groups in your area. Understand the multi-level appeals process: reconsideration, hearing before an administrative law judge, appeals counsel, and then federal court. For disability claims, gather strong medical evidence early and consider how your condition affects daily functioning in a work setting. Keep a symptom journal if needed. Talk with a financial planner about how Social Security fits into your larger retirement picture, including taxes on benefits and required minimum distributions from retirement accounts. Review your overall retirement wellness, physical health, social connections, and financial buffers, because benefits are just one part of a secure later life. The system still has real challenges. Processing times for claims and hearings can be lengthy in some parts of the country. The agency has made progress in recent years, reducing disability claim backlogs, but high volumes in certain states continue to create pressure. This legal change adds another layer that may influence how cases are decided and appealed, potentially leading to more thorough initial decisions and better explanations for claimants. Looking ahead, we may see more litigation testing specific Social Security rules that rely heavily on agency interpretation. Courts will have to decide case by case what the statutes actually require. This could bring more consistency in some areas and more variation in others, depending on how different judges read the law. Over time, clearer judicial guidance may actually reduce some disputes if the agency aligns its practices accordingly. It could also encourage Congress to write clearer laws in the future to avoid ambiguity. For the average person watching this, the key takeaway is empowerment through better access to independent review. If you've paid into the system your whole working life, you have a stronger legal framework supporting your right to challenge decisions that you believe misread what Congress wrote into the law. This doesn't mean every claim will succeed or that benefits will suddenly increase. Social Security still operates under the same eligibility rules, contribution requirements, and funding structure. What it does mean is that the playing field in court is more level when legal questions are at stake. If you're currently receiving benefits, keep an eye on your annual statements and any notices you receive. If you're not yet retired, use tools like the Social Security Retirement Estimator to get a sense of what to expect under different claiming ages. And if you run into issues, remember that resources exist, from the agency's own appeals process to community legal aid organizations and private attorneys who handle these cases. Many people feel overwhelmed when dealing with federal agencies. The process can be slow, paperwork heavy, and stressful, especially when you're on a fixed income and every month counts. This ruling doesn't eliminate those frustrations overnight, but it does strengthen the protections available when you need to push back on a legal interpretation. Taking small steps like organizing documents, seeking advice early, and staying informed can make a big difference in your peace of mind and financial security. In the comments, feel free to share which state you're in and any general experiences you've had with Social Security without sharing personal details. Hearing from real people helps others know they're not alone. Many viewers appreciate learning from each other's journeys while respecting privacy. If you found this helpful, consider subscribing and turning on notifications. Future videos will look at how this ruling plays out in specific situations, such as common SSDI appeals, survivor benefit coordination, retirement claiming strategies, and the impact of WEP GPO provisions. We'll also cover practical tips for organizing your paperwork, preparing for a hearing, and building a strong retirement plan that includes Social Security as one important piece. Retirement security is built on many pieces: savings, pensions, investments, part-time work, health insurance planning, and yes, the benefits you've earned through a lifetime of work. Understanding changes like this one helps you protect what you've worked for. The Supreme Court has shifted the legal landscape, and knowing what that means puts you in a better position to navigate the system effectively and plan with greater confidence. Thanks for watching all the way through. Take care of yourselves and the people who depend on you. We'll see you in the next video with more straightforward, useful information on retirement and benefits topics from Senior Wellness Hub.